Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and my partner David Nagman is still traveling, but he should be here by the next program that we will do. In the meantime, once again we have with us attorney Lutka Zimochak, you might have seen her on the previous two programs, and she is a partner in our same firm NPZ Law Group. Lutka, welcome.
Thank you. Hello, everyone.
By this time, everybody knows you. Okay, last program we were talking about what if the comprehensive immigration bill does not get passed and people continue to remain in long lines, and we talked about some options in the family preference categories, and we want to continue. That is a very important program. I know that many of these people that are watching the program today can benefit from some of the tips and the suggestions we are giving. So, Lutka, we did not talk specifically about the F3, that is the married sons and daughters of U.S. citizens, and the cutoff date there is
2000,
December 8,
2002.
2002. So how many years? 11 years more to wait.
Yeah, that's correct.
Terrible. So again, I'm giving you now this mic you have in your hand to tell our viewers what can that person do, your client who is waiting in the F3 line. How can we help?
Well, first of all, I do ask whether they're still married.
Correct.
Sometimes they get divorced.
And sometimes
the spouse will pass away.
Yeah.
So that's very important because that would put them into the
Right.
different categories.
Correct.
That's very important. And then I do look again at non-immigrant options to see if there is H1B, L1, O1, different types of non-immigrant visa
similar to what
options.
we talked about the other categories in the last program.
Exactly, that's correct.
So that's that. Then what happens? So supposing you find out your client's divorced or the spouse is dead, then what will happen?
They will not be in F3 category. They will move. They will move into F1 category, which is a little better. Yeah. I believe the current cutoff date is 2006. So it's going to put them in a good situation.
Very good. So that's all. People don't realize that. They are
Yes.
still sitting in F3. I'm in this category whenever the turn comes. But this is a very good suggestion to
And
our viewers.
they have to let us know, and then we would notify the immigration.
But there also, that last time we talked about other options that people can look on a temporary visa, the H1 option, the L1 option. And one of the other options we did not talk about, that options are available here also, right? The other option we did not talk about is getting the green card based upon investment in the US. So that is the employment fifth preference, which is current. The question is a subject by itself that we can take maybe an hour to explain. Briefly speaking, that if a person is willing to invest $1 million in his own business, in which he will also, the business has to hire at least 10 US workers, and it has to be a new business, not an existing business, then that process takes about 18 months, 20 months to get the green card. Or there is a regional centers in which you can put $500,000. You have to do nothing there. You don't have to hire anybody. It's indirect creation of jobs, and based upon that, again, you can get a green card in about 18 months. So people ask a question, supposing I'm already waiting in the family preference or employment preference, can I go through that route?
Yes, of course. You can have as many petitions as you like. You can have 2, 3 petitions filed. No problem at all. And if you do have a family petition, we also will look at the possibility of the employment petition.
Correct.
Maybe the person has a master's degree, PhD degree, or has many publications, and there we could do an EB1 case.
So if they're waiting in India, for example, many years, they can at least come here on a temporary H1 or L1 visa and join the family, and that will continue parallel. It's not that by doing that the previous petition will be cancelled. That's not the case, right?
Yeah, definitely no.
Okay, let's move on now to employment preference. Now we were talking in the previous program and this program what happens to the long waiting lines and how we can help these people to come on a temporary visas, on a permanent visas under different categories. So let's continue now this same type of discussion for employment categories. Now, employment categories EB1, which is current. Who is EB? What is EB1? EB1.
EB1, that's obviously preferred because it's current. It's for multinational managers. Then it's also for outstanding professors and researchers. And then there are people with extraordinary abilities. Somebody that has many publications, won major awards, has many memberships in professional organizations, and did contribute to the field.
That's a very good description. In a way, sometimes I tell people, if you know what is L1, that's more or less the same requirements of having a subsidiary company or a branch office and at least 1 year of experience in the foreign company and the parent company in the last 3 years, and all those requirements that we need to evaluate the eligibility for L1 visa are helpful also in evaluating the eligibility under AB1 visa. Would you say? I mean, not a little bit difference maybe, but more or less, would you say that?
Yes, usually when I do have an applicant who has L1A visa, we certainly do go for EB1 category, which is current.
So we don't have to worry about the waiting lines on this one.
No waiting line,
okay,
no waiting
good,
line, no
good.
problem.
Now a difficult subject, EB2. What's EB2?
EB2, that's a category for somebody with a master's degree, advanced degree, or it could be bachelor's degree plus 5 years of experience.
And the present cutoff dates is current for all the countries.
Yes, but not for India.
Not for India. Bad news.
Not for India.
Bad news and a good news. The bad news is that it has been stuck to 2004 for a long period of time. And in the month of August, it has jumped more than 3.5 years or so to January 1, 2008, which is a very, very good news for people who already filed. And remember in July of 2007, when the same thing had happened, all the employment preference categories became current. Many of our clients filed the I-140-485, so they got the permission to work. Some people got permission to travel, but they are still waiting because it went back again.
But at least they have employment authorization and the travel document.
True,
that's
true.
important.
But they are looking forward to permanent green card so that they can buy the houses, they can bring more children in this world, and they are always anxious. How many calls you get from all those clients who are waiting? When?
Many.
Okay. So the good news is that the jump from 2004 to 2008 is a big, big jump, and hopefully, I don't know whether that will increase or it may go back also. But right now, if you have a cutoff date of prior to January 2008, you should be getting your green card. Request your lawyer to contact the immigration service to pursue your case before it retrogresses, would you say? Right?
That's correct. That's correct.
Okay. Nevertheless, let's talk about EB3 and we come back to the EB2 again.
Okay.
Now, what's EB3?
EB3, it's a category for professionals. It's either somebody only has a bachelor's degree or it's somebody that's a skilled worker, for example, which would require just a few years of experience.
2 years or more in a skilled kind of work. Yeah.
Exactly.
So this category, again, there is a difference between the cutoff dates for the other countries as well as India. Unfortunately, now why? First of all, let's go back for 1 minute. Why is that so? Other countries like Bangladesh, Pakistan, many of these countries have a cutoff date of 2009. If they file in 2009, they can now get in 2013. India, born, this goes not with the nationality or citizenship, the country of birth. What's India? January 2003. We are in 2013. The guy still has to wait 10 years?
Yes.
Isn't it sad?
Unfortunately, yes, but there is a huge, tremendous demand for the green cards from India. Therefore, it's retrogressed.
Yeah. I think the rule behind this is two things. Basically, it is a per country limit, basically. Per country limit limits the number that can be, from a country where a lot of people are coming, then that portion of allocation gets over very quickly.
Yes.
The countries from the number of people coming is less, then their category dates are advancing much faster. They are putting the two different categories. Other countries and India, other countries and China, other countries in Mexico or Philippines. So
But Michael, how about if Indian national is married to somebody from, let's say, Europe?
I think you are talking about a rule of cross chargeability, which means if an Indian national for whom this petition is pending and waiting in the big line, and the wife is now born, he realizes that wife was born in Bangladesh or some other country, then if the immigration service has to be notified, they don't look at this themselves. Somebody has to tell them, oh sir, please, there's a rule of cross chargeability here, put me in that line, not this line. So it's
So then both the Indian husband will be put into the line that is,
the wife's country of birth.
yeah, so that's very important.
So that will move much faster then,
Yeah.
right? Now people don't realize, no, this is the reason we are here telling our people about all these things that many of people do not realize. So this is a very good option, but the usual option that we talked about earlier also, that even if a person is waiting in India, for example, EB3 category, and he's got a degree, he's an engineer, or he is a system in computer science, and easy for his family to find an employer in the US, would you not consider an H1B option?
Certainly. If there are H1B available, I would definitely consider H1B or O1 or maybe exempt H1B.
Correct.
It just
Also, how about moving him somehow from EB3 to EB2? Because again, big difference between 2003 and 2008.
Yeah, it happens very often since there is a long wait. Maybe the applicant received a master's degree. So maybe there is a possibility potentially that we could move him to EB2 category and reapply and file a new petition. Certainly, it happens very often. And then we would use the prior, we would retain the prior priority date.
That's a wonderful news. So if a person filed, let us say, EB3 case was filed in 2008 or 9, or earlier to 2008. EB3 was filed in 2007, let us say. And we move him into EB2, which is current of 2008. Boom.
Boom, then
Gets
we can
away
go
right
ahead
away.
and get a green card. Yep.
But I mean saying, but moving is not like a chess game to take from here and put there. How do you move? What do you have to do to take him from 3 to 2?
We would have to file completely new petition, and again, we would have to see the resume, because either we would use perm or labor certification, but for some people, maybe national interest waiver.
Yeah.
That's
So
something
basically,
that,
I think you're talking about like looking very closely to see both to the alien, that's the applicant, and the employer, because now we are saying he might have had a whatever the bachelor degree and the job required a bachelor degree, so he remained in EB3. This new employer, and sometimes the same employers, for a job that has become now available, we have to see that whether this person qualifies for the EB2 category by virtue of having a master's degree.
exactly. But also, maybe they could even petition. If the person qualifies, they could be a self-petitioner where you don't need
In
an
some
employer.
cases, in some limited cases, some limited
Some
cases.
limited cases, but
And
it's
then-
important to know.
Yeah, and the employer also, we have to see what is the type of job, what are the job duties, what is the requirement. Where people, all the time, people, I have a PhD, I have a master's degree, job is a programmer, okay, but we got to see this job, does he need a master's degree? If the job needs only a bachelor's degree, you may have a PhD. That doesn't help, does it?
It doesn't.
Why
and,
so?
And we cannot tailor the position based on the applicant's education. That's very important.
So we don't know whatever the employer's requirements are. Employer says, it is the policy of my company, you can see all other employees, we only hire master degree holders for this kind of job. That is a good example of the employer's requirements. And sometimes they look also at the practice in the business. What is happening in the trade and the business generally, other companies, is not just my company, but in this kind of job, especially in research. All, in my opinion, and correct me if I am wrong, all research positions need a master's or a PhD.
I absolutely agree.
So there is not much issue.
Absolutely
They know
agree.
research.
Yes.
They are not say, oh, why
Yeah.
can't you do a research for a bachelor's degree? That's not.
No, I absolutely agree with you.
I've talked a lot to talk about, Lotka. Time goes away very quickly. But hopefully we will come back again and talk some other subjects, and you give a very good program here with you. You give a lot of good information to our viewers. And any of the viewers, if you have any questions, comments, any suggestions, feel free to contact us. Our contact number, email addresses, phone numbers are shown on the screen. We thank you very much for being with us today, Lutkaji, and thank all of you for watching the program. Goodbye.
Thank you. Bye-bye.